Hi, my name is Zach McGee. I'm the chairman of New Media Legal Publishing, the sponsor of this CLE program. The presenter of this program is Andrew Struve. Andy was a brilliant, experienced, and highly successful litigator here in Southern California. On a personal level, he was also a warm, caring, and infectiously funny human being. Sadly, Andy passed away in July 2023 after a brief illness. The program you are about to watch was recorded a few years ago, but I've confirmed that the content still reflects the current state of the law on this topic. Reposting the program allows lawyers like you to continue to benefit from Andy's wisdom, and it allows those of us who knew Andy well to keep him around us for at least a little bit longer. I hope you enjoy it.
Hi there. I'm Andrew Struve. I'm a lawyer from California, and today we're going to be discussing dating and romantic relationships in the legal workplace. And one of the most interesting things, at least to me, is how the rules and the attitudes have evolved over the last 50 years or so. And so you'll see from the beginning of the presentation, the focus is mainly on relationships between legal professionals and clients and other related parties. And then, of course, there's been a paradigm shift in how we look at dating, not just in the legal workplace, but it applies in various entertainment industry. Harvey Weinstein brought us that, but the At Me Too movement has become very important in the legal workplace, so I want to focus on that. But just to give you an overview of what we're talking about, we'll start off with the rules that came out around the time of the model rules of professional conduct. And they were really focused on relationships between attorneys and clients. And to speak to that, there are certain fields of practice that are particularly more vulnerable to the creation of a, I won't say non-professional, but I'll say personal relationship. Matrimonial law, I would say, is one. It's sort of similar to the problems you have with psychologists and psychiatrists, and particularly vulnerable patients. And so, but it applies across the board. It could be in any field of law. And so the beginning focus generally factors that were outlined by the ABA and others were factors you should consider when contemplating a relationship with a client. And so what was publicized, promulgated, is were viewed as two types of sexual misconduct. The first one being unwanted sexual advances, and the second one being quote-unquote consensual attorney-client sexual advances. And in the slides you'll see that we put consensual in quotes because in certain circumstances the attorney-client relationship can be a touch coercive, frankly, when the client has a particular dependence on a lawyer in a matter of grave personal circumstances, whether matrimonial law or criminal law. And so one can raise hypotheticals or just think generally about how such a relationship might not be typically defined as consensual. And so I offer that for your consideration. It was said in the old days that the focus was really on consensual relationships because disciplining an attorney for unwanted sexual advance is simpler. This, again, is the older view. We'll talk about the newer view. But in any event, the American Bar Association Model Rules of Professional Responsibility, if you like citations, 1.8 sub J, says a lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the lawyer-client relationship commenced. In other words, the ABA's view at the time that the rule was promulgated was that a pre-existing sexual relationship was not as of much concern as one that began at or after the time that the attorney-client relationship was formed. Now, I would offer to you a personal view that once an attorney-client relationship is formed, the relationship often, you can imagine, would change. It would be harder for, say, a client to end such a relationship because of the effect that it might have on their representation. But that was not defined in the early rules in ABA Rule 1.8J. California regulates attorney-client sexual relations under the Rules of Professional Conduct 3-120. And the first thing it says is, for purposes of this rule, sexual relationships means sexual intercourse or the touching of an intimate part of another person for the purpose of sexual arousal, gratification, or abuse. Modernly, one could view that as overly simplistic. There are relationships, and we'll call them relationships, but I have done a lot of cases over the years where the touching or whatever is not actually done for sexual gratification. It's done by, and this does not just apply to lawyers, I've seen it quite a bit with doctors. I think the technical psychological term is frauderism, and it's not for arousal but for control. And so we have to kind of keep that in mind. Again, you're going to see in the course of our talk that there's a lot of nuances that the rules do not address. But in any event, California Rule 3-120 says a member shall not require or demand sexual relations with a client incident to or as a condition of any professional representation. Well, that makes pretty good sense. Also says a lawyer shall not employ coercion, intimidation, or undue influence in entering into sexual relations with a client. As a litigator, coercion, intimidation, or undue influence is somewhat hard to define. In some cases, it's obvious. In others, again, it's much more nuanced. And the rule in California 3-120 also says that the lawyer shall not continue representation of a client with whom the member has sexual relations if the sexual relations cause the member to perform legal services incompetently in violation of a different rule. Well, that makes sense, but again, defining competence under those circumstances, I know plenty of people who defend lawyers and other professionals in these situations, and it's not quite as easy to tell as you'd think. And then the rule goes on and says that this does not apply to sexual relations between members and their spouses or to ongoing consensual relationships which predate the initiation of the lawyer-client relationship. Logically, those are two different things. Sexual relations with one's spouse is a bit different from a circumstance where one doesn't have a formal relationship, formal at law, but it happened to predate because, again, like we said, relationships between lawyers and clients can change. That kind of dovetails into what I was saying earlier about even a pre-existing relationship can change quite a bit once there's a need for representation. And I cited off the top of my head matrimonial cases, criminal cases. You can even imagine real estate cases. We don't have walls and walls and walls of appellate decisions for nothing. There's a lot of facts out there that bear on these things. New York, by way of example, traveling 2,452 miles from where I sit right now, Disciplinary Rule 1-1027 says that a lawyer or a law firm shall not engage in domestic relations matters and begin a sexual relationship with a client during the course of the lawyer's representation of the client. And then that makes perfect sense to me. That, again, it goes back to what I was mentioning earlier about the vulnerability in the domestic relations context. The logical term called the implied negative pregnant suggests that it might be okay to do that in non-domestic relations matters, but even that can violate the code of conduct, and it should. Okay, so having read to you the fairly long-standing California Rule 3-120, it was in force in its present version about 25 years, and then the similar New York Rule 1-102 sub 7. It'll come probably as no surprise for you, at least it hopefully won't be a surprise, that these rules as they're currently configured have become somewhat unworkable, in fact, more than somewhat. And that prompted a big change on the part of those two bars. And it's entirely likely that we're going to see more states on the way. So you'll recall the prohibitions in California 3-120. In summary, requiring or demanding sexual relationships as a condition of representation, or employing coercion, intimidation, or undue influence in entering into a sexual relationship, or continuing representation of a client with whom the lawyer has sexual relations if the sexual relations cause the member to perform legal services outside the scope of confidence. And you'll recall also that New York's section was very similar. It's kind of interesting. It says at 1-102 sub 7 that a lawyer or a law firm shall not in domestic relations matters begin a sexual relationship with a client during the course of the representation. And that was unworkable in a number of respects, including, I understand that people are especially vulnerable in domestic relations matters, but the salami's getting sliced way too thinly here in terms of these distinctions. And after a great deal of discussion, both states adopted the original rule of professional conduct, Rule 1.8.10, which is from the model rules. And essentially, this is a lot easier to understand and comply with because it completely forbids even consensual relationships or those that are initiated by the client, even where there is no quid pro quo or coercion or intimidation or undue influence. And this is a much more bright line, kind of a hands-off prohibition. It reads in full, a lawyer shall not engage in sexual relations with a current client who is not the lawyer's spouse or registered domestic partner, unless a consensual sexual relationship existed between them. It says when the lawyer-client relationship commenced. I think they probably mean before the lawyer-client relationship commenced. But in any event, what we're seeing is progress and parity and more focus on the client. And that takes us into a nice turning point, which is the as a segue, let's put it, the increasing focus not just on the clients, but also on colleagues, staff, vendors, and many others. Very hard to differentiate between a relationship that's become exploitative and one that hasn't. Outright demands for sex predicated on certain things of representation, certain aspects of representation, that's an easy one, right? But again, it's heavily nuanced, and I would suggest not doing it at all, right? The last time I checked, there were around 330 million people in the United States. Slightly more than half of them are female, if memory serves. And I don't know how many clients you have, but surely you could have 100 clients, right? But you're still left with 329 million and change. And so there must be somebody else out there, would be my recommendation. And then Colorado, Indiana, Kentucky, New Hampshire, Ohio, Texas, Hawaii, and Rhode Island have found outright that a sexual relationship between attorney and client materially limited the attorney's responsibilities to the client because of his own personal interests in the sexual relationship. And what I would suggest is, in some cases, a lawyer who engages in such conduct may be aware of exactly what she or he is doing. And by the way, it's usually a he, but you have to consider both. I'm sure there are quite a number of occurrences where the reverse occurs. And so it's hard to have a sexual relationship with anybody without having a personal interest in it. And so I'm not sure how you do business with anybody in that situation and not have a personal interest. And Colorado, Kentucky, Ohio, and South Dakota, they do a pretty bright line rule that says having a sexual relationship with a client reflects negatively on the attorney's fitness to practice law. So from a macro view, the rules were written a long time ago. They've evolved. But again, we've talked a lot about the fact that the rules that were promulgated back, starting about, well before I was born, focus on the relationship between attorney and client. So now we switch gears to the modern world a little bit. And now we have an increased focus on relationships with coworkers, whether they be other lawyers, associates, summer associates, paralegals, secretaries, interns, somebody who works in the copy room. And they are entitled to be free from unwanted harassment. And, we can call it the #MeToo movement. But it is a fairly recent recognition of the fact that the same duty of respect is owed to everybody in the office. And by the way, what you'll find out in a few minutes, it's not just limited to everybody in the office. It's limited to your clients' employees, people whom you interact with, your outside copy service, your outside attorney service if you're a litigator. They are actually entitled to be free from unwanted advances. And sometimes an advance may be perceived in good faith, if you like, as a joke or a shot in the dark, or maybe this will work. I would caution and suggest that if it does work, you're not out of the woods. I ran into a case recently where a lawyer had a meretricious and extramarital relationship with a subordinate for over 15 years that even began at a prior law firm and carried on, I suppose, without particular rancor for quite some time, over 15 years. The relationship soured. The current firm got sued. The very senior partner got ejected. And significant legal bills were incurred. So let's just talk lightly about some of the things that the movement has done. Law firms like to write paperwork, right? And with settlements, especially in the context of a sexual harassment case, and we can just round off and call it that, no matter what the conduct was. law firms, when they write a settlement agreement, and most of these cases settle, they would contain a non-disclosure agreement. Well, that doesn't work anymore. There are a few celebrities I shan't name, and a few executives I shan't name, who were the catalyst, if you would put it, for the elimination of the ability to put in non-disclosure agreements. So at last count, and I'm sure it's been added to, Arizona, California, Maryland, New York, Tennessee, Vermont, and Washington prohibit the use of non-disclosure agreements, or NDAs as they're called, in harassment settlements. And this is a paradigm shift in how these cases are approached. It used to be routine, it used to be accepted, silence was bought. We have a former president who gave that a shot, and even though I believe an NDA was signed, the NDA went by the wayside. And so, and you know, you can draw your own conclusions about whether that's a good thing. I tend to think it's a good thing because you've already got somebody who's been at least perceived as having been wronged. And the idea of burying it under a rock is not helpful to the other people who work in the firm or in the company if it's not a law firm. So the concept is, as it's been described by some professors, is these bills forbidding NDAs are designed to shed light on the sexual harassment issue, to make sure survivors aren't forced into silence, and making sure misconduct and abuse is actually exposed so it can be addressed head on. This means a lot of things. It means, for example, that it encourages other victims in the organization to speak up and not to have fear. And I think an NDA, and this is a personal thought, signing an NDA implies a touch of shame or approbation, and it sort of takes a bad situation and makes it worse. And so originally California had passed a law. You can guess where this originated, but it called out some very specific potential harassers: investors, movie stars and producers, and legislators and lobbyists. That one's a little bit lost on me, although I do know a few current candidates for office in California who have a sort of checkered past in this respect, some decades ago. But the law came after literally hundreds of women came forward in news reports to detail their harassment in places like Silicon Valley, Hollywood, and the state capitol in Sacramento. Another set of bills brought to us by originally a former movie star turned governor of California focuses on how companies must address the problem of harassment. And this is where it gets interesting, because some of the ways to address this, rather than humiliating the victim, you can identify and punish the perpetrator. And The other thing that these bills do is they require mandatory training on what constitutes harassment and what constitutes unacceptable workplace behavior. And so again, to take a step back, we go back a number of decades, and the laws governing attorneys focused, as we started with, on relations between attorney and client. Well, those all hold true. Don't take those and push those off to the side. But again, it's a question of how one treats everybody, from the associate to the person who wheels the mail cart around. You simply cannot do it. And the ramifications of it are appalling. Also, the NDAs, I should speak to the fact that there had been a trend to avoid NDAs and to avoid settlements by instead paying the complainant a bonus or pay increase or promotion or sneaking the payout into other paperwork. And that's now banned also in a number of states, including California. So the concept of harassment in the workplace, I think the legal workplace is particularly susceptible to the concept of harassment because in a law firm, I've always been a law firm person, people often work in teams, they often work together. Some cases I had one that lasted 5 years. You get to know the people very well. There is a slang term that would refer to somebody of the other gender that you worked with as your work wife. And the trouble is, when you work that closely with somebody for so long, you do tend to bond with them. And when you bond with somebody, it's easier to feel like you can take advantage. Even it may not feel like taking advantage. You just feel like you're part of a team. The team may include martinis, the team may include travel, and too many martinis and travel have led to a lot of problems in this area. And so, we've had examples of, I can guarantee you, and I don't know if the allegations were true or not, but Justice Kavanaugh did not enjoy his confirmation hearing, I can guarantee you. And Justice Thomas did not enjoy his confirmation hearing either. They both were confirmed. I don't know if the stories are true or not, but the fact that the accusation was made is something that really created professional problems for two of our Supreme Court justices who are currently serving. And so again, let's go back. We started off with regulation focusing on the attorney-client relationship and how the attorney treats their clients. And that was the primary focus. Culture, developmental advances, basically growth of consciousness has changed the way we look at these things, and I think that's for a good thing. And an attorney is generally held to a higher standard. So are corporate level executives. Usually, the more senior a person is, the greater the trouble for the organization and the greater the trouble for the person. If you happen to work in a law firm of any size, you'll note that you have a marketing department, usually rather a robust one, and they spend their time focusing on the reputation of the firm, trying to get stories into Westlaw publications and others. They focus on buying tables at charitable dinners. They focus on philanthropy generally. They focus on promoting their brand. They focus on diversity. They focus on inclusivity. And there's a lot of money, take my word for it, there's a lot of money that's spent on those activities. And then when a harassment allegation arises, especially with a senior person, firm leadership has a couple choices. One of them is to try to ride it out and litigate it. Another one is to simply let the accused, not necessarily guilty, but let the accused depart. And sometimes those departures are very public, right? And the other thing that you'll see, in addition to the loss of brand, you'll see loss of clients. There are clients who will walk away from a law firm where such scandals have surfaced. Whether they've been substantiated or not, the client simply won't put up with it. They don't wish to be associated with that law firm. It'll come as no surprise that there are plenty of competent law firms in the United States. And if you're anything resembling a viable client who pays its bills, you can find somebody, often in the same building, who can do the same work without staining you with their reputational problem. So you have your marketing, you have your branding, you have your positioning, you have your philanthropy, right? If you look on the webpage of just about any large firm, they will talk about having a safe, supportive, collegiate environment that builds careers of younger people and that brings them up and takes care of them and mentors them and so on and so forth. And if necessary, and I'm glad it's not, I could probably write such a page just sitting here. The problem is, if you're going to talk the talk, you have to walk the walk. And so you can put that stuff on your website, but if you don't actually act on it, then not only are you misrepresenting yourself as an organization, but you've also created one hell of a deposition exhibit for the harassed employee who sues you and asks, you can imagine the questions. Who wrote this? Why was it written? Who approved it? Did the board approve it? Who was in charge of ensuring that this actually was carried out? Who was in charge of ensuring the safety of the employees. And by safety, again, I mean supportive, collegiate, and protective. Okay? Recruitment. When you have a scandal inside a law firm, one thing law students love to do is talk about law firms. And I have stories about certain firms that I won't tell, where a partner has engaged in behavior that becomes notorious, and certain fine law schools, in fact Ivy League law schools, have for a time refused to accept interviews from that firm. So now what you've managed to achieve is you've cost the firm talent when, as a lawyer, you engage in that kind of behavior. And, you know, really, the talent is and not just the talent, but the raising of the talent. I interviewed potential summer associates for years for a large firm. And it always made me so happy when one of them made partner and then ultimately made equity partner, because it means, A, I and my cohorts made a good decision, and B, we actually walked the walk, and they stayed, right? And so that's a valuable thing to have. And misconduct by a senior attorney, even if it's punished, still will follow the firm in that respect. And that not just goes to recruiting, that goes to attorney retention as well. And I can tell you that it goes to morale of the junior lawyers. They wonder, is this going to happen to me? Am I safe here? Is the firm going to be safe here? With the departure of somebody in leadership, how much is that going to damage the firm financially? Should I start talking to recruiters? It's a big problem. I don't want to pick on anybody, but let's just say one of the big four accounting firms, chief executive, confirmed that in a recent year it had fired about 20 partners in the United Kingdom over 4 years for inappropriate behavior that included bullying and sexual harassment. And it was announced by leadership that there would be a zero tolerance policy on such conduct. So what do you do as a firm? What do you do as a firm? There used to be a joke in the medical community that, and you can remember this probably from the bar exam, that medical malpractice, so somebody gets in a car accident, right? And so the tortfeasor injures them. And then the injured person goes to the hospital and the surgeon commits medical malpractice. And the rule, as I remember it, is the tortfeasor is responsible not just for the injury, but also along with the surgeon for the medical malpractice. And the way we remembered the rule was medical malpractice is not, it's not just foreseeable, it's inevitable. And I tell that not to make a joke, but if a firm is very, very lucky, it will never encounter one of these very high-profile attorney on attorney or attorney on staff abuse allegations. But what a firm can do is it has to expect that it may. And there has to be a general philosophy and construct in place. And by analogy, I'd say it's very similar to when a firm suffers a cyber attack. You have to have a plan in place for a cyber attack. A good firm will usually have a relationship with a good crisis PR firm, because whatever the crisis is, you will need them. And part of the plan in these situations, and it hasn't happened yet in the hypothetical I'm talking about, but one of the plans is, what is the response going to be generally? To whom is it going to be communicated? When is it going to be communicated? And then you have to talk about the confidentiality of an investigation, because one has to be fair to all parties involved. And so outside counsel is also retained for inside leadership. Communication should be prepared. And the scenarios and the planning work best if they're done in advance. So let's go back again to the beginning. We talked about the regulation focusing on the relations between lawyer and client. One shall not exploit a client for their own purposes, and so on and so forth, and pre-existing sexual relationships versus post-retention sexual relationships, and God help us, demanding sexual relationships in exchange for additional representation or discounted representation. The Me Too movement is demanding that law firms say no to behavior that might have been tolerated 10 or 20 years ago, or even sooner. And so it's almost harder, in my view, for the older lawyers like me to understand that, and stuff that went over fine decades ago is no longer fine. And the repercussions go right to the top. For you senior lawyers who may be watching this for MCLE or for abject fun, which I doubt, you can think about CBS's former chair and CEO, Les Moonves. You can think about Harvey Weinstein. These people are fired based on allegations of sexual misconduct by lawyers. Here's something that's, I think, reasonably important, and also sad and somewhat scary. And I think the statistics that have been reported bear out to the fact we have MCLE that focuses, it's usually titled in various states something like elimination of bias. Well, heck, this is a poster child of bias And with apologies to anyone with disabilities, that was not intended to be offensive. The American Bar Association and Minority Corporate Council released a study, and it was entitled, "You Can't Change What You Can't See, Interpreting Bias in the Legal Profession." So what they did is they took a survey of over 2,800 in-house and law firm attorneys and found that 25% of the women respondents reported some form of unwelcome sexual harassment at work, and more than 70% of all respondents, regardless of gender, reported sexist comments or jokes. And we really need to cut this out. Again, hearkening back to the beginning, all the attorney-client stuff, still very important, still very in force. But we have to broaden our thinking in terms of the concept of quote-unquote relationships in the workplace. So, EPL, right? Employment Practices Liability Claims. It was, I believe, Aon who reviewed their case history from 2005 to 2017 and found that there were 1,315 claims filed for harassment of this nature in the workplace. Now, these also did include retaliation, wrongful term, and discrimination based on race. Of these claims reported by Aon, and let me make sure it is Aon, which it is, of these claims, law firms and their insurers paid a total of over $91 million in judgments and settlements and over $44 million in defense costs. And Aon believes that these numbers were underreported because in many cases, law firms represent themselves, try to handle it themselves. There's often a retention on an EPL policy. They don't wish to report something that would be within the retention, but then would increase the policy premium. So, ideas, right? Best practices. Institute a code of conduct if you don't already have one. It's the firm's blueprint, essentially. And it should come from the very top of the firm, and it should set forth behavioral expectations for relationships. And I don't just mean sexual relationships. I mean any kind of relationship that could be viewed as offensive. The sexual ones are easy. There are others. The code should set forth the corporate values and should set forth, frankly, a zero-tolerance policy for disobeyance of the code of conduct. And also a clear, definitive statement that a reporting person will not be retaliated against. Now, a code of conduct is great, but as I mentioned earlier, if it's not enforced, it's just put out there and ignored, that's worthless. There has to be somebody to which this can be reported. It's hard in these kind of circumstances of unwanted attempts at relationships for a subordinate to decide whom to report the incident or incidents. Does one report it to their direct supervisor? Well, it's usually their direct supervisor who perpetrated it. One thing that is, depending on the size of your organization, is to have an ombudsman. There are also companies that provide anonymous tip lines so that one can make a report without fear of ramification, and then it'll be investigated and professionally. And the policies need to be updated, right? But the trick is to make the lawyers aware of the policies. And I don't just mean at the time of hire. The time of hire, one is presented with a huge binder that will include, if you're happy enough to have one, a code of conduct, but will also include a lot of junk like how to work the copy machines and a telephone list and how to order a hotel room. And you don't just dump those all together. I'd suggest that the code of conduct be featured prominently before there's discussions about library budgets and those kind of things. So again, just to recap another thing I said for the lawyers out there, you can be liable not just for people, not just for conduct, unwanted conduct. And by the way, I said earlier, and I say it again, conduct that's wanted can become unwanted. The relationship sours. Somebody moves back in with their wife. Somebody finds a different girlfriend. Somebody offends the person they're in a relationship with, okay? So please bear that in mind, because I think it's very serious. And I will reiterate examples of things that attorneys can be disciplined for in seeking relationships. In Delaware, the penalties extend to unpaid interns, to employee applicants, and to apprentices. Think about that, applicants. If an attorney hits on an applicant, that is a violation as well. And in New York, contractors, subcontractors, vendors, consultants, the people who fix your air conditioning system in the office, the person who fixes the copy machine, that also is an offense under the New York rules. And this is going to continue to evolve. And so, it's easy for me to say, just don't do it. It's easy for me to say, 330 million-ish people in the United States, surely you can find somebody outside the office. I would strongly recommend that, because these kind of things, even accusations where there was no touching, there were just remarks, or there was nothing. Hopefully, you don't get fired if there was nothing. But the trend, I have to be honest, is to terminate you. You'll get a couple months' pay. You'll get put on what's called garden leave, which means stay at home, don't come near the office, don't you dare contact the person involved. It creates a bit of a conundrum also for you when you apply to your next firm. So why did you leave Dewey, Cheatham, and Howe? Well, what do you say? Word gets around. I again would suggest you don't do it. And in a lot of cases, by the way, when these incidents occur, this is not a quiet termination. Because a lawsuit gets filed, first of all. That's usually what happens. Once the lawsuit gets filed against the lawyer, the firm has to act. And the firm will say, we investigated thoroughly, and we have interviewed witnesses and the accuser, and we have terminated senior partner X. And that gets picked up by all the online blogs, the newsletters you get every morning. They flood your inbox. And so the humiliation is astounding. At one point, I won't name the firms, firms that you know very well were not secretive in their actions of termination. In statements to the press, they gave the names of the partners, and they said the terminations were because the firms were acting to protect their values. And so it's very important to understand how the Me Too movement has expanded. And it's designed to alter behavior, and that's a good thing, right? This is behavior that needs to be altered. I would point out, by the way, that even if you get terminated or what have you because of a relationship or an attempted relationship gone sour, you may well be subject to professional discipline. It doesn't end with just what the firm does. Depending on the circumstances, you may very well capture the attention of your state's bar association, depending on how busy they are and how interested they are, frankly. Another thing is, the firm knows that if they allow somebody to stay in light of those circumstances, then it actually, God help us, could encourage others to act likewise. And the problem mushrooms. And you simply can't have that. You simply can't have that. I go back to the clients. The clients expect the same behavior from their vendors, and a law firm is a vendor, okay? They expect the same behavior from their vendors as they would expect from their own employees. And so we're rife with examples of well-respected or formerly well-respected, up to you, important figures who have suffered, wrong word, who have sadly experienced these sorts of events. If you think back to about 2018, well-regarded Ninth Circuit judge, Chief Judge, I believe at one point, Alex Kaczynski was subjected to a number of allegations by former clerks and externs. One said that he showed her pornography, and another said he shared his list of his sexual conquests from college. And he's off the bench now. When you think about it, one of the more wonderful things about Kaczynski is that, assuming he participated in this behavior, at the same time he was sitting on the bench hearing cases of alleged sexual harassment while allegedly participating in it himself. And so what I would leave you with is, lawyers are humans, at least most of them. They're not infallible. They have their own challenges. They have their own insecurities. The trouble is, it's kind of like being a cop. There are things that other people can do that we just can't do. And so one of the better things about how to handle this is to remember that because law firms are businesses with multiple partners, they can make their decisions about how to handle things. And most law firms, the partners are no dummies, and they figure out how to address such matters. So I appreciate your time very much. I appreciate your thoughts very much. Again, I began by saying that we were going to look at the concept of dating and romantic relationships in the legal workplace. I hope what I did is I gave a broader view of what the legal workplace is. And the title really shouldn't just be dating and romantic relationships. It should really be the introduction of attempted romantic relationships, or shall we say, non-legal related relationships in the workplace. It can be a career breaker, and you owe it to yourself, and you certainly owe it to everybody around you, clients, staff, all the way down the chain, just to not do it. That would be my strongest recommendation. I really do want to thank you for your time and attention, and I hope this proves helpful. Thank you again.